Alright, so moving on from the idea of setting the agenda and formulating policy, by this point we also have to consider how the public is going to react to it. So we have to figure out how we can best legitimize public policy choices in a way that the work that goes into determining how best to handle the problem isn't ultimately wasted, because we can get citizens hopefully on board before we hit that point. We need this buy-in. The fact is that any type of policy comes with some sort of cost. Whatever we decide to do, there will either be a real cost, some type of externality, there will be an indirect cost. It just depends. With as many people as we have in society, not everybody is going to agree that something is a good thing and not see there being some detriment or downfall to their forced participation. But more than that, we need to hit a point where citizens simply accept the decrees of government as being correct. It's a psychological property to see something as being legitimate, to seeing that something was done in a way that you agree with. Now, for the average citizen, there are two levels of legitimacy. The first and the most basic is procedural legitimacy, the idea that the rules were followed, the process in place was followed. Now, you may not agree with the legitimacy of the process, but hopefully as a citizen you're still going to agree that whatever process is legally laid out and spelled out is in fact true. And then secondly, it's substantive legitimacy, and this is, do you agree with the actual policy choice that emerges from whatever body is working on it? Ultimately, you want both. Procedural guarantees you some small baseline. Substantive guarantees you that people are happy with the outcome. We have questions about governmental activity. I mean, obviously, since 2009 with Rick Santelli and the Tea Party, we have serious questions about what government should and shouldn't do. And this matters in the United States. We know that the idea of legitimacy is both what we would call a variable and a constant. It's a variable for the individual. Each individual has different views on legitimacy of government action at different times based on different policy areas in their own personal life circumstances. And we also know that it's a constant with time. Now, it may shift, but it's always there. If you look at your book on page 97, it's table 5.1, where they walk through confidence in American institutions from 1983 to 2008, looking at how many people say they either have a great deal or quite a lot of confidence. The military has actually gone up. 53% in 1983, 71% in 2008. Not particularly surprising, given that in 1983 we're still coming off of Vietnam, where the number was even lower. But if you look at everything else, it's dropped. Organized religion, 62% to 48%. The Supreme Court, 42 to 32. The presidency, 43 to 26. Public schools, from a peak of 49 to a current low of 33. Newspapers, 38 to 24. Organized labor, from a peak of 28 to 20. Big business, from 28 to 20. Congress, from 28 to 12, and that was in 2008, and we now see even lower levels. So institutionally, we have to recognize that citizens have what we could refer to as a reservoir of respect. There is this mass collection of citizen points they have to allocate, and once that reservoir runs thin, it's going to apply across the board in a sweeping fashion to different areas. And as a result, as a member of government, you need to realize that every policy choice you make, no matter how basic and mundane it is, needs to be justified to the public. And if you can't justify it in a meaningful way, then perhaps you shouldn't be reaching the policy choice. There are modes of legitimation. There are two axes on which we can look. The first being the characteristics of decisions, and this is page 99, it's figure 5.1, the modes of legitimation. The characteristics of the decisions. Are the decisions that are being reached being done so in a majoritarian or a non-majoritarian manner? So does the average citizen have a say or not? And then it's the range of actors. Is it mass or elite? Is it everybody getting a say, or is it just a small number? So again, looking at it, the characteristics of the decisions, is this something where you're going to have a majority of people supporting it, or can a non-majority be successful? And then, are we talking about everybody, or are we just talking about the elites? And this gives us the different modes of legitimation. If it is a majoritarian decision and the mass public is going to be involved, we're looking at direct democracy. We're looking at referendums. We're looking at initiatives. If it is going to be majoritarian but only involve the elites, we're looking at congressional action. If it's non-majoritarian and it's going to be mass actors, we're basically talking about either A, very strong interest groups, or B, more likely, we're talking about revolutionary actions. And if it's non-majoritarian and it's elite, then we're getting into the court system, we're getting into administrative regulations, we're getting into a smaller subgroup of elite actors who are not having to reach any type of majority verdict in the end to get what they want passed, to get what they want to be implemented. And again, these four, this is something very important to know. Very important to know for the test. So let's start by looking at legislative legitimation. What can we do with Congress? We know that government as a whole is too large and involved to rely solely on our congressional body. Members of Congress are already overstressed, and they are overworked. We knew this. If you look at the stimulus bill in 2009, 92% of congressional members openly admitted that they had not read the entire bill, and further, had not mandated that their staff, or anybody in their staff, read over the entire bill. So it tells you they're already busy. But they're still the crucial source of primary legislation because they write the laws. If that wasn't enough, we then asked them to oversee the laws. And they have a strict process in place. There is procedural legitimation on how a bill becomes a law. It gets introduced, it goes to a committee, it goes down to a subcommittee, hearings, votes, back to the committee, hearings and votes, back to the whole body, hearings and votes, passed on to the other side. So if it starts in the House, it goes to the Senate. If it starts in the Senate, it goes to the House, and it goes back through. Then at the end, if both sides pass it, and there's any type of discrepancy between the two versions of the bill, it goes to a conference committee that irons out those differences onto the president's desk. The president can either sign veto or pocket veto. If he chooses to veto or pocket veto, back to Congress to try to see what they want to do. That procedure is in place and it works. But we never look at kind of the sausage factory side of what goes on behind the formal procedure that everybody buys into and likes. The fact is that a committed and well-supported minority can wreak havoc. Hello, Ted Cruz. Hello, Tea Party. Hello, John Birch Society after Kennedy was elected. Hello, Christian Coalition after Jimmy Carter. All of these groups can have a role. We have what we call a partisan analysis. The partisan analysis is where individuals try to convince members of Congress that the piece of legislation some analyst wants is something that they want as well. We try to sell them. We make it a very individualized discussion. We've talked about log rolling and pork barrel, but these both play a role in legitimacy. Our book actually uses vote trading words to describe log rolling, and it can be thought of that way. But it's always involving legislative initiatives that one side doesn't care about. And with pork barrel, it's hard to get rid of pork barrel. Everybody wants to bring the money back home, but bringing home the bacon increases the cost of government exponentially. Because if you think about it, if I'm a member of the Senate, and I vote yes for a bill with your pork barrel legislation, I'm going to want my own. So you take the extra $4, $5, $50, $100 million that we spend on one individual for pork barrel, and then realize that there's 99 other members who are going to want the same type of money. And we wonder where we get deficits from. Obviously, the key for legislative legitimation is to maximize the coalition. We know that there are varying intensities of participants in coalitions. And this is where it gets scary. What happens? Again, use the Senate because there's 100 members. Let's say there are 49 members who strongly oppose a bill that is about to be passed. And there are 51 members who don't really care that have placed pork into that project. So we have a majority of members making the decision, even though they don't care and the results of the decision won't impact them, and basically saying screw you to the 49 senators who do care, who do have something on the line. That's a very scary thought. We look at the ideas of impositions. We always have this idea that we could impose something on them, and whether that makes anything any different. It's difficult to reflect the preferences of participants as they try to gain net satisfaction. Kenneth Arrow was kind of he's referred to as a social choice scholar who looked at different ways to reach rational conclusions. And he said that the only way in which we can really reach these decisions is to impose them, but philosophically we oppose that. And for Congress, it's hard to look at imposition because they're going to be responsible for the second round of legitimation when they look back on whatever's occurred in this particular policy area through oversight procedures. It's hard for Congress to oversee the policies they've enacted because, number one, they're already at a loss for time, and number two, there's a need for new legislation. They can't simply not write new legislation because they're too busy overlooking previous legislation. And as a result, oversight in Congress tends to be more of a fire alarm than police attention. Conditions at Walter Reed, about 6, 7, 8 years ago, show this perfectly. Once people realized how bad Walter Reed was, the fire alarm went off and everybody rushed to figure out what had happened and to stop the problems. But there had been no what we would call police attention. We weren't looking out and looking for problems. We weren't letting policies and areas and agencies know that Congress was interested and Congress cared and Congress was involved. And that allowed for bad things to occur. Off of the legislative piece, let's go to the administrative process. We look at things like rulemaking. Rulemaking and binding regulations, which basically act as secondary legislation. We look at the Federal Register, which is printed every day and tends to be between, 80 and 90,000 pages long by the end of the year, where we look at every bureaucratic rule created. We look at the Code of Federal Regulations, where we look at any type of regulation currently in force. And if you think about it, 3 areas of public policy, agriculture, labor, and the environment, account for almost 25,000 pages in the CFR. You add in other areas of government, and that document is massive, and it's a bear to understand. Rulemaking, though, is not majoritarian in nature. It is technical. It is less tied to politics. It is tied in now today to regulatory analyses, where we basically try to figure out the cost benefits of regulations. OMB is kind of forcing that upon us. The important part is there is public access available. The APA allows for individuals to be involved, and as a result it can be more democratic for some members of society than Congress is. If there is an open discussion or open comment period, everybody gets to directly interact with the decision maker. Now, having that access does not mean equal protection. That's the difference. Simply being able to write your thoughts on a proposed rule doesn't mean you're necessarily going to be heard. And that's difficult for folks to understand or wrap their heads around, where they would much prefer to know that their voice is actually being heard. And in this case, you're kind of sending off your comments without knowing what happens. If we look at writing regulations, there's really 4 different ways that we can see regulations being written. First being formal rulemaking. The formal rulemaking process is a bear. There are hearings, there's oral testimony, lawyers get used, it's time-consuming, it's cumbersome. Where we typically see this are things like the FDA, the Nuclear Regulatory Commission, areas of government where there are major concerns, major potential issues. There's legal language involved, you have 2 sides that both have arguments, and it's easier to just have them hash it out. If you look at informal rulemaking, a couple of steps to go through. First, you publish in the Register a notice of intent with a certain regulation. You give a set of months, and then anybody who may be affected by the rule can offer opinions about the content. Then you issue a draft of the regulation, and you have another waiting period, and you get responses to the draft regulation and what folks think and what folks want to see. Then, based on those responses, the final regulation comes out, and at that point it has the force of law. You also have hybrid rulemaking. Hybrid rulemaking tries to compromise the thoroughness of the formal process with the relative ease of the informal process. There may be some cross-examination of witnesses. It's not a full-scale judicial hearing. It's a little bit easier. And then lastly, we have what we call negotiated rulemaking, which basically means in certain times we realize it may be easier to just let the parties involved negotiate a rule rather than administratively go through it. And this came to be when the federal government realized in 1990 that it was just taking too much, it was taking too long, it was unnecessary, but there were easier ways to handle the problem. Overall, it can be up to an 18-month process. We talked last week a little bit about neo-corporatism. And neo-corporatism basically looks at the role interest groups play. U.S. interest groups are not granted quasi-official status related to the economic or social group they belong to. In Europe, they are. And when that difference happens, affected U.S. interest groups don't get brought together, whereas European interest groups have a commonality that they're able to utilize when trying to influence some type of change in government. So they have a foot in the door. What you always worry about with regulation, especially administratively, though, is the idea of agency capture, where the group that is supposed to be regulating an industry all of a sudden starts meeting the needs of the industry. So if you look at the FAA is spending lots of time with airlines and pilots and plane manufacturers, and they're supposed to be regulating them. But since they work directly with them on a day-to-day basis on every major issue, you worry that all of a sudden they're going to be receptive to the needs of the airlines because they know the airlines and they like the airlines and they like these people. If we flip to the courts are another non-majoritarian body. It is the decision of the judge or a panel of 3 judges, or if it gets to the Supreme Court, the panel of 9 judges. It involves litigation, and it's all based on the Supremacy Clause, which says all the laws and treaties made in pursuance of the Constitution are the supreme law of the land. They got this power from Marbury versus Madison. John Marshall, our second Chief Justice of the United States following John Jay, basically says it's up to the courts to decide whether or not a law conforms to the Constitution. So when you think about it, the ability of judicial review for constitutionality at the Supreme Court level was a power the Supreme Court wrote for themselves, recognizing that it doesn't exist anywhere else. At the end of the day, the courts have one of 2 options. They can further legitimate some policy that's already been passed, or they can instead destroy the legitimacy of that policy. And if you use, segregation and desegregation, the Supreme Court legitimated the idea of separate but equal when they decided the Plessy versus Ferguson case and said separate but equal was okay. And then they came back in 1954 with Brown versus the Board and destroyed the legitimacy of separate but equal by saying it's not okay. And we see with issues like due process and equal protection where these types of things have arisen time and time again. Switching from the courts to popular legitimation, which again, from a personal level, I will tell you is the scariest part of government in general. Direct democracy always looks good on paper, it looks good in theory, but in practice it opens us up to so many potential problems that it's hard to understand how it's workable. 2 different types of direct democracy to talk about. First, the referendum. The referendum may be something where the legislature or another authoritative body has said, we want citizens to sign off on this, or we want them to tackle this issue, we don't want to make it. So it goes to the ballot. And what typically happens, of course, is once a referendum goes to the ballot, just like an initiative, we spend millions of dollars trying to convince different sides to show up and vote for or against on it, depending on our personal standpoints and personal beliefs. And then we have the initiative. The initiative permits voters not only to pass on an issue, but to put them in government by allowing them to place the ballot on, or to place the issue on the ballot themselves. All they have to do is get signatures. And once it's on the ballot, again, millions and millions and millions of dollars get spent. California's state budget is basically tied at this point due to the number of initiatives passed. If you look at Proposition 13, which is our most famous initiative probably in the history of the United States, this is a California initiative. It limits property taxes and also several important environmental laws. The problem with this is that, of course, sorry, I haven't slept much. Once you limit property taxes, you still want government to provide all the other services, but you're completely depleting their revenue streams. You can also look and see where popular legitimation can be used in good ways to overcome legitimation activities that were either conducted at the elite level or were conducted at the non-majoritarian level that citizens disagree with. And there's nothing necessarily inherently wrong about this type of deliberative and strong democracy. It just opens the door to future budgetary problems. To some degree, many argue that there's a reason the general population was not given the power to make these decisions by the founders. And there's a reason the individuals who show up at the ballot box to vote were not elected to, public office to make these types of decisions. So there's clearly good and bad about it. But the hope is that through popular legitimation, you're going to see differences. And we don't have a slide written on this, but and the book doesn't talk about it, but if you look at revolution as a form of legitimation, that's fairly concerning. If you look at the Arab Spring, that's revolution and protest. But what are they actually making more legitimate? Their right to give a protest? Their right to protest? Or is the delegitimation of the status quo in the national government in these cases actually providing legitimation to the general population that policies are going to change? That's kind of the million-dollar question we'd spend some time talking about in class.